When Drew and John asked me to speak today, I have to say I was a little ambivalent. I was curious to see if a bunch of data scientists really wanted to listen to a lawyer, and could I really engage them? And on top of that, you know, as an IP lawyer, we kind of deal with all different phases, and yet today we have students, we have startup companies, we have professors, we have well-established companies, and so I was trying to figure out how I could present something that kind of meets everybody's needs at the same time. So what I'm going to attempt to do is try to come up with some common IP and privacy mistakes impacting big data. So as you know, the work and planning necessary to successfully start a new company or launch a new product in connection with big data is prodigious. Yet with all the financial plans, the marketing strategy, and the product developments, entrepreneurs, developers, and investors often skip what I think is the most important step, which is protecting their valued assets through proper IP protection or devising the proper privacy strategy. As you just heard, I'm an attorney at Lowenstein Sandler, and I chair the IP practice, which is part of the tech group there. And over the last 12 months, we've closed over 350 angel and venture deals. And as part of that, I often see the good and bad of IP, and it's the IP and privacy issues, in my opinion, that often slow down the transaction. And a big reason for that is that IP or our privacy policies were not developed or implemented early in the project lifecycle. So, as I said, what I'm going to do today is identify some mistakes and some proposed solutions. It's by no means exhaustive. I'm not sure if I'm going to answer the question just posed, but we'll see what happens. It's a starting point. So patents. Yes, big data solutions may be patentable, but is it worth it? And how can I account for its value? Stated differently, is there a patent filing gold rush going on? Since the mobile device war started between Apple and Samsung and a lot of others, I've seen a real change in attitude by investors, and more relating to patent filings directed to software processes and business methods. The large Silicon Valley companies are now filing patents in record numbers. Startups are filing patents like never before. And Twitter, for example, is filing, but with caveats on how they're going to use it in the marketplace. Placing value on these patents is difficult. However, if you don't file, in my mind, you don't have a chance to obtain any value whatsoever. As a side note, note to build a patent portfolio to defend against what we always hear are patent trolls is a fool's errand, as they just don't care because they don't make anything. So going back to the filing issues, it will take between 3 and 5 years before they'll even have a chance to issue. Since you don't know where the market is heading, it's smart to develop a targeted patent strategy, not based on volume, but on quality. It may matter one day, and in my opinion, the risks definitely outweighs the costs. However, the assessment of the value of such filings is nearly impossible to quantify. So what are some of the common or really simple errors and solutions? Often what I see are people rush an idea to market or before an audience without adequate patent protection. If a new or useful idea is publicly disclosed or offered for sale, foreign patent rights are lost. In addition, if you then wait for more than a year after that public disclosure, you've actually lost your right to file in the United States. So a solution is a patent application should be filed in the US Patent and Trademark Office prior to that initial disclosure. If it's not possible, arrangements should be made to disclose that original thing under an NDA or in secrecy. There is that 1-year period from that initial disclosure to file it to save your rights, but if you don't do it, it's lost. And in fact, in March of 2013, we're going to change our law to be a first-to-file system to harmonize our laws with the rest of the world. So early patent filing will be key. If the proper description of your system is already in place, say a white paper, a functional spec, a provisional patent application can usually be filed relatively cheaply and quickly, and then from there, so as to kind of get your application in the queue, and then from there you have up to a year to convert that to a non-provisional application, which is probably what you're all more familiar with, that will ultimately get examined. Second, a common mistake with patents is not updating patent protection after the initial filing to allow for the evolution of the concepts of your product. You could be basing your future on a product and a patent that no longer exists. So what should you do? Entrepreneurs and officers should periodically consult with their patent attorneys to update their portfolio to reflect the changes. Timely review can prevent loss of rights. As for the patent trolls out there, there's not much you can do to keep them away. There's always pending legislation in Congress, but don't count on it. I know you won't like my answer, but getting sued by a troll is often a sign of success and an ugly cost of doing business. So trademarks and domain names. Big data is no different than any other industry. Trademarks and domain names should not be ignored. I've seen too many trademark issues of late which have slowed the launch of a product by requiring the rebranding just weeks or months from the actual launch date. Stated differently, too often, products are launched without properly clearing the name. People believe that if a domain name is available, so is the trademark, and vice versa. Unfortunately, neither statement is necessarily true. A classic example, and I've seen this over and over again, is companies spend $50,000, $100,000 or more to buy a domain name, only to later find out that the actual trademark is not available for use or registration. So be careful. In either case, a product name, a company's name or product name that causes confusion with somebody else's product is the basis for a claim for trademark infringement. Each use may be an invitation to a lawsuit and ultimately an injunction. So what should you do? Do a search, clear it, make sure all the records are there. Once you get through the clearing process, then you file for your trademark application and you purchase your domain name. It should only cost a few $1,000s, but if you delay it to the end, the time and money is much greater. Next, developed work product, content and data and code. Who owns it and when? Just because you hired somebody to create something for you, or you receive data from a third party, does not mean you own it or have the unfettered right to use it. In fact, as to ownership, it's the exact opposite. The creator of the work owns that work and all IP rights embodied in there, unless there's an affirmative grant in writing to the contrary. As for data, you need to spell out the rights being obtained for your use, or you're subject to risks and risk of claims of misuse. So again, be careful. So what's the mistake here? Trusting ownership of material such as software, data, and content that is automatically secured because it was produced for you, delivered for you, and perhaps you even paid for it. Therefore, what you must do, and this is a big issue when it comes to investment, you must get the ownership of the work or the data in writing. Companies will be hard-pressed to prove their original work is theirs unless they institute a company-wide procedure for the written assignment of all ownership of work. Stated differently, absent an agreement to the contrary, the creator of the work of the people working for you will actually own it. This is predominantly with third parties, not your employees, but you should have the proper policy in place with your employees, which is what, as well as necessary privacy policies to spell out data ownership and use rights. Many investments fail when companies can't produce a proper chain of title. It's quite simple, but failing to do it can have dire consequences, so be careful. Open source. I often refer to it as the silent trap for the unknowing. I continue to see open source issues slow deals in both venture investments and M&A transactions. It doesn't break them, it just slows them. Investors are nervous because if not properly used, or better said, if the code is subject to the wrong agreement, an entire code base may need to be publicly distributed in source or dedicated to the public. As we all know, open source is a great tool for productivity, interoperability, and more. But if the code is subject to the GPL, LGBL, or other like agreements, the risk, as I just said, is that code is going to go out into the public, which is extremely dangerous for the company and could totally diminish the value of the company. So what do you need to do? It's really quite simple. Use open source, but manage it tightly. Make sure it's logged and the related license is identified in review. Even GPL code is okay if used in the proper way. What spooks investors is when companies don't know what they're using, how they're using it, or what license it's subject to. Finally, privacy, the ultimate hornet's nest for big data. I never thought I'd hear the word creepy as part of my practice, but somehow it's regularly uttered because, quite frankly, overcollection of data can be just creepy. Think about Path, the social network that touted itself as being privacy-friendly, but then accessed users' mobile address books and transferred it to its servers, without providing the users with notice and without obtaining the user's consent. This violated both the privacy policy, Path's own privacy and the iTunes Store privacy policy as well. The reason was obvious. It was to obtain better user experience. But without clearly stating this intention, Path was accused of violating users' rights in a couple of nasty class action lawsuits. Yes, they were ultimately dismissed, at least for the moment, but it was a PR nightmare just the same. And lots of other apps are doing it. I recently read that 11% of the free apps on iTunes Store have the ability to access users' contacts. Does that make it okay? What are the 5 words that you just never want to hear describing your app? Mine are just a little bit creepy. They are likely to be followed by loud outcries from the press and the user community, class action lawsuits, perhaps a call from the FTC, and a thud from your investors, which could drop you cold. It just doesn't get better than that. So what should you do? If you inadvertently over-collect data and use it in a way that exceeds the scope that you've obtained consent to do so, and you're caught red-handed, here's some advice. Rule 1, ask someone who knows. Don't respond off the cuff to the bloggers or anyone else. Rule 2, apologize instead of good practices? Absolutely not. Do be contrite. Do say you're sorry. But do fix the problem, and fast. Rule 3, hindsight is 20/20. Privacy by design is the new corporate hotness. If there's a less intrusive way to collect data that you need to achieve your business purpose, find it and use it. Rule 4, no surprises. Opt in, express consent in a clear and concise way, always. Rule 5, unfair or deceptive trade practices. You can drive a truck through Section 5 of the FTC Act, and they like to drive trucks in Washington. Rule 6, agility is good. The FTC is not a good business partner. It's not somebody you want or need. But once you start to draw their attention, expect them to call for more information, then a preliminary investigation, then a full investigation, then a consent order, and then you have to check with them before you do anything. This is not how you want to run your business. This is a tricky business, as use of data in a way that is consistent with notice and choice of the consumer can still be, quite frankly, creepy. Think about, how can my use of customer data be perceived or interpreted? What if it ends up on the front page of the Wall Street Journal or the New York Times? Stated differently, the public opinion backlash can actually be worse than the FTC enforcement actions. A great example of this is how Target collected data from its customers to figure out that a teenage girl was pregnant before her father did. For the startups in the audience, I'm sure many of you have copied the privacy policies from Google, Facebook, or a competitor. We see it all the time. While it's great to start as a reference point, it's a slippery slope when the only change in the language you make is the company's name. In fact, quite frankly, I'd prefer no policy to a policy that you can't comply with. Do it right.
So we are back. Yeah, thank you, NYU, for providing us with some very exciting theatrics in terms of the fire alarm. You can't plan for those things, and I appreciate everyone being very understanding of that.
So clearly, I'm not going to go back to where I was. Clearly, once I mentioned creepy and open source, the room got too hot, everybody had to leave. So I'm really not going to finish it, except to say somewhere up there is my name, my email address, and my telephone number. Please call me, follow up with me. I'll be happy to answer any questions. My partner, Ray Thack, who's on the venture and deal side's in the back of the room waving with a salmon-colored shirt, I think. But thank you very much. I appreciate your time.